Good morning, friends. Today, we deal with Article 15 of the Constitution of India, which provides the prohibition of discrimination on the grounds of religion, race, caste, sex, or place of birth. Clause 1. The state shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, place of birth, or any of them. Clause 2. No citizen shall, on the grounds only of religion, race, caste, sex, place of birth, or any of them, be subjected to any disability, liability, restriction, or condition with regard to subclause A. Access to shops, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. Clause 3. Nothing in this article shall prevent the state from making any special provision for women and children. Clause 4. Nothing in this article or in Clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. Clause 5. Nothing in this article or in subclause G of Clause 1 of Article 19 shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes, insofar as the special provision relates to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in Clause 1 of Article 30. Clause 6. Nothing in this article or subclause Z of Clause 1 of Article 19 or Clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any economic weaker sections of the citizens other than the classes mentioned in Clause 4 and Clause 5. Clause B. Any special provision for the advancement of any economically weaker sections of citizens other than the classes mentioned in Clause 4 and Clause 5, insofar as such special provision relate to their admission to educational institutions, including the private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in Clause 1 of Article 30, which in the case of reservations would be in addition to the existing and subjected to the maximum of 10% of the total seats in each category. Yes, friends. Now, let us have a discussion in Clause 1 of Article 15. While Article 14 guarantees the right to equality in general, whereas Article 14, 15, 16, 17 and 18 provides or guarantees the right in specific fields. So, in my opinion, Article 14 is the foundation on which different floors are constructed. Article 15 is the first floor, Article 16 is the second floor, Article 17 and 18 are the third and fourth floors respectively. Article 15 Clause 1 prohibits the particular aspect of inequality or discrimination as special grounds only on the religion, race, caste, sex, place of birth, or any of them by the state. We know the meaning and definition of the state under Article 15, Article 12 of the Constitution of India, and we know who are the citizens and who are not the citizens And in part 2 of the Constitution of India, which extends Article 15 to Article 5 to 11 of the Constitution of India. The significance of the word only is that if there is any other ground or consideration for the differential treatment besides the religion, race, caste, sex, place of birth, which are prohibited in Clause 1 of Article 15 of the Constitution of India, the discrimination will not be unconstitutional, which means the discrimination based on any of these grounds and also on other grounds is not hit by Article 15, Clause 1. For example, in our Vizag steel plant, the women were not employed, taking into consideration of their physical fitness, because the duties in the steel plant are very heavy and unsuited to the health and strength of the women. And we know that it is the duty of the state to protect the health and strength of the women under directive principles of state policy. This discrimination is the ground of sex and the physical fitness for the same work in heavy industries like Vizag steel plant. The word only means solely. The discrimination solely on the grounds of religion, race, caste, sex, place of birth is unconstitutional. The discrimination or other grounds, in addition to the grounds mentioned in Article 15, Clause 1, are not unconstitutional. The word discrimination means to make an adverse distinction or distinguish unfavorable from others. If the law makes discrimination as any of the grounds of religion, race, caste, sex, place of birth, that law can be declared void. In Naid Sukhdas versus State of Uttar Pradesh, AR 1953, SC 384, it has been held that the mandate in Article 15, Clause 1 extends to the political as well as other rights. In Saurav Chaudhary versus Union of India, 2003, AIR SCW 6392, it was held that the reservations on the basis of domicile is not impermissible in view of Article 15, Clause 1, as discrimination on the grounds of birth, not on the grounds of domicile. And what is domicile is already explained while dealing Part 2 of the Constitution of India. Friends, Kerala Electricity Board versus Sinai AR 2008-730 Kerala, it has been observed that the exclusion of women, not exclusively based on sex, but taking into consideration of peculiar nature of the duties to be performed by electricity workers, is not violative of Article 15, Clause 1. Yes, friends. Yes, friends. I have already given an illustration of our Vizag steel plant. When we read Kerala Electricity Board Thiruvananthapuram versus Sinia AR 2008-730 Kerala, we know and we remember that Visakhapatnam steel plant is the best illustration for this. Now, Clause 2 of Article 15, no citizen on the grounds only of religion, race, caste, sex, place of birth, or any of them, be subjected to any disability, liability, restriction, or conditions with regard to Clause A, Subclause A, access to shops, public restaurants, hotels, and places of public entertainment, or Clause B, the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of the state funds or dedicated to the use of the general public. Yes, friends, class 2 is the wide important. Article 15 class 2 is a specific application of the general prohibition that is contained in Article 15 class 1. Article 15 class 2 provides that no citizen shall be subjected to any disability with regard to access to shops, public restaurants, hotels and places of public entertainment, or the use of wells, tanks or bathing ghats, roads and places of public resorts, maintained wholly or partly out of the state funds, or at least they are dedicated to the use of general public exclusively on the grounds of religion, race, caste, sex, place of birth, or any of them. Yes, friends. Article 15 clause 1 prohibits the discrimination by the state, whereas Article 15 clause 2 prohibits both the state and private individuals from making any discrimination on the grounds that are mentioned in clause 1 and 2. Article 15 clause 1 and Article 15 clause 2 applicable only to the citizen and not to the non-citizens. Yes, friends. The object of Article 15 clause 2 is to eradicate the abuse of Hindu social system and to herald a united nation by we the people of India. No law, no custom, no usage could authorize any person to prevent Harijans, depressed classes, or like from having access to any public places that are mentioned in clause 2 of Article 15. Article 15 clause 2 inhibits only discrimination founded inter alia upon the descent. Transgenders have been systematically denied the rights under Article 15 clause 2 that no one can be subjected to any disability, restriction and condition in regard to the access to the public places. The Constitution of India is not only a political document, it is a social document too. It is not only the character of a political independence from colonial rule, but also a document that aspires to overcome the social hierarchies that have been arisen in Indian society. This transformative ambition of the Constitution is exhibited in particular through its horizontal rights provision in Article 15 clause 2, Article 17, Article 23, which directly target the exploitative practices at the level of individuals and communities. Yes, friends, the object and the aim of Article 15 clause 2 is social transformation. Now, clause 3 of Article 15 of the Constitution of India. Nothing in this article shall prevent the state from making any special provision for women and children. Clauses 3, 4, 5 and 6 are concrete expressions for the Article 15 clause 1 and 2. These exceptions are considered as a protective discrimination. It is a discrimination, but it protects the equality. The expression any special provision is more important. So, let us see some legislations. Sati Prohibition Act 1829, Immoral Traffic Prevention Act 1956, the Hindu Women's Rights to Property Act 1937, the Dowry Prohibition Act 1961, the Indecent Representation of Women Prohibition Act 1986, the Maternity Benefit Act 1961. The very recent legislation is Protection of Women from the Domestic Violence Act 2005. All these enactments are special provisions, specially made to protect the women. And now let us see some of the provisions or legislations in favor of the children. Children Pledging of Labor Act 1938. Child Labor Prohibition Regulation Act 1986. Prohibition of Child Marriage Act 2006. Right of Children to Free and Compulsory Education Act 2009. The Protection of Children from the Sexual Offences Act 2012, etc. These are the legislations or the special provisions made for the protection of the children and women. Yes, friends. Now, clause 4 of Article 15 of the Constitution of India. Nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens. I am stressing the words any socially and educationally backward classes of citizens, or for the scheduled castes and scheduled tribes. The term backward classes is not defined in the Constitution. Article 340 empowers the President to appoint a commission for this purpose. On the basis of the report of the commission, the President may specify backward classes of citizens. The President of India appointed a commission in the year 1952 itself, and the commission submitted its report in 1955. The government did not accept the report. Now, the other question arises, who are the scheduled castes? As per the clause 24 of Article 366, scheduled caste means such castes, races, tribes, or parts or groups within such castes, races, tribes are deemed under Article 347 of the scheduled caste for the purpose of this Constitution. Then who are the scheduled tribes? As per Article 366, clause 25, scheduled tribes means or scheduled tribes or scheduled communities are parties or groups within such tribes or tribal communities as are deemed under Article 342 to be scheduled tribes for the purpose of this Constitution. One important judgment in this respect is in the case of Tapan Kumar Roy versus Convener, AR 1989, AP 132, it has been held that the presidential notification under Article 341, Clause 1, cannot notify all India scheduled caste. It can declare particular caste as a scheduled caste only in relation to particular state. As such, there cannot be any list of all India scheduled caste under any classification. And let us see brief background of clause 4 of Article 15. Originally, yes friends, clause 4 of Article 15 of the Constitution of India, nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens. I am stressing the words any socially and educationally backward classes of citizens, or for the scheduled castes and scheduled tribes. Originally, Article 15 contains only 3 clauses. The communal GO issued by the government of Madras government, apportionating the medical seats against Brahmins, backward classes, backward Hindus, non-Brahmins, Harijans, Anglo-Indians and Muslims was struck down as violative of Article 15 Clause 1 and Article 29 Clause 2 in Champakam Dorai Rajan versus State of Madras, AR 1951 SC 226. So, on the same day, on the self-same day, another judgment categorically stated that the expression backward classes could include various communities who had been classified or identified on the basis of their caste. This is held in Venkatraman versus State of Madras, AR 1951 SC 229. After these two decisions, our parliament enacted first amendment and inserted clause 4 of the Constitution of India. The first case reached to the Supreme Court on clause 4 of the Constitution of India is A.R. Balaji versus State of Mysore, AR 1963 SC 649. In the state of Mysore, the reservations were in force since a few decades prior to the commencement of this constitution and continued thereafter, friends. This must be a noted point. On 28th day of July 1958, the state of Madras issued an order under Article 15 Clause 4 of the Constitution of India declaring all the communities except Brahmin communities as socially and educationally backward and reserved 75% of the seats in educational institutions in favor of socially, economically backward classes and scheduled castes and scheduled tribes. Such orders were being issued in every year with a minor variations in the percentage of reservations. Yes, friends. The grittinity of the Mr. M.R. Balaji judgment is Clause 4 of Article 15 is a proviso or exception to Clause 1 of Article 15, friends. And also, it is an exception to Clause 2 of Article 29, friends. For the purpose of Clause 4 of Article 15, backward classes must be both socially and educationally, and not socially alone or not educationally alone does not make the reservations under Article 15, Clause 4 of the Constitution of India. And the caste is a relevant factor in determining the backward classes, but cannot be sole factor, and caste alone cannot dominate the determination of the backwardness. Christians, Jains, Muslims do not believe in caste system. The test of caste cannot be applied to them, friends. I repeat, Article 15, Clause 4 does not speak of the caste, but only speaks of classes. Caste and classes are not synonyms. The impugned order proceeds only on the basis of caste without regard to other relevant factors, and that is sufficient to render the order invalid. The reservations made under Clause 4 of Article 15 should be reasonable. It should not be surely as to defeat or nullify the main rule of equality contained in Clause 1 of Article 15, friends. That is why the reservations should not exceed 15%. A provision under Article 15, Clause 4 need not be made in the form of a legislation. It can be made by an executive order, is also a law within the meaning of Article 13, Clause 3, Subclause A of the Constitution of India. In case of Devadasan versus Union of India, AR 1964, SC 179, the Honorable Supreme Court held that the rule of carry forward
though valid, but if it results in more than 50% of vacancies being reserved in particular year is bad. This is what is held in Devadasan versus Union of India. In Chitralekha state of Mysore, AR 1964 SC 1823 held that the identification or classification of backward classes on the basis of occupation, income, without reference to caste is not bad, and it does not offend Article 15, Clause 4. In the case of state of Andhra Pradesh versus Balram, AR 1972 SC 1375, Honorable Supreme Court held that the caste of a person cannot be the sole test for ascertaining whether particular class or community is backward class or not. In Guntur Medical College versus Mohan Rao AR 1976 SC 1904, an important question arose before the court. The question is, a person originally belonged to scheduled caste, converted to Christianity, and he then reconverted to Hinduism. Can he claim the reservation under Article 15, Clause 4 of the Constitution of India? The court decision is that if a person whose parents belongs to scheduled caste before their conversion to Christianity can, on the reconversion to Hinduism, be regarded as a member of the scheduled caste. Only if he accepted as a member of that caste, on such acceptance, he would be eligible for the benefit of the reservations under Article 15, Clause 4. In Indrasena versus Union of India, AR 1993 SC 477, Supreme Court held that the classification of backward classes into more backward classes is constitutionally valid, which is declared invalid in case of M.R. Balaji versus State of Mysore, AR 1963 SC 649. Yes, friends, Clause 5 of Article 15 of the Constitution of India, which provides nothing in this article or in subclass G of Clause 1 of Article 19 shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and scheduled tribes, insofar as such special provision relates to their admission to educational institutions, including the private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in Clause 1 of Article 30 of the Constitution of India. The placement of Clause 5 of Article 15 of the Constitution of India in the Equality Code by 93rd Amendment is the greatest significance given the absolute necessity of achieving the egalitarian and social justice goals that are implied by the provisions in Clause 5 of Article 15 of the Constitution of India. Clause 5 of Article 15 is not to violate of the basic structure, but in fact, Clause 5 of Article 15 strengthens the basic structure of our Constitution. Clause 5 of Article 15 does not abridge the basic structure of our Constitution. Article 15, Clause 5 is constitutionally valid, and to the extent it allows the reservations in favor of socially and educationally backward in the state or state-aided educational institutions subjected to the exclusion of the creamy layer. Clause 5 of Article 15 of the Constitution, therefore, enables the state to make a special provision by law for the advancement of socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes insofar as such special provisions related to their admission to the educational institutions, including the private educational institutions, whether aided or unaided by the state. But other than the minority educational institutions referred to in clause 1 of Article 30 of the Constitution of India. Now, the last clause, clause 6 of Article 15 of the Constitution of India. Nothing in this article or subclause Z of clause 1 of Article 19 or clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any economically weaker sections of citizens other than the classes that are mentioned in clause 5 and clause 4 and clause 5 of the Constitution of India. And any special provision for the advancement of any economically weaker sections of citizens other than the classes mentioned in clause 4 and clause 5, insofar as such special provisions relate to their admission to educational institutions, including the private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in clause 1 of Article 30, which in the case of reservations would be in addition to the existing reservations and subjected to the maximum of 10% of the total seats in each category. This clause, that is clause 6, is inserted in the Constitution by 103rd Amendment in the year 2019. The provisions allow the state to provide for affirmative action, including the reservation for economically weaker sections, that EWS, in the year 2021. The Union government issued a notification to introduce economically weaker sections reservation. Various parties challenged the 103rd Amendment in the Supreme Court on the ground that Clause 6 of Article 15 violates the basic structure of the Constitution of India, which in their view, the Constitution does not allow the reservations on purely economic criteria. In Janhit Abhiyan versus Union of India, the judgment delivered on the 7th day of November 2022, the 5 judges bench of the Supreme Court held that the 103rd Amendment did not violate the basic structure. With this discussion, we conclude Article 15 of the Constitution of India. Thank you, friends. Thank you, one and all.